Well, we're out here beside the Federal District Court in Honolulu, Hawaii, where we just had our first hearing suing the state of Hawaii on their magazine ban and their assault pistol ban. And I'm here with our Chief Counsel, Mr. Barry Arrington from Texas. I know it's tough duty to come out here to Hawaii, but somebody had to do it, right?
Someone had to do it. We took the bullet, so to speak.
But we're here at the courtroom because we just got done with our first hearing on the preliminary injunction. I mean, I know how it went, but I'm a layman. So let's ask our attorney what you think of what just happened.
So we brought this case last year and we put all of our papers in and we've laid all the arguments out. And as an attorney, you're always anticipating, well, what are they going to say that I did not anticipate? Are they going to come up with some argument that carries the day? Because this is a pretty simple case. We have a commonly used arm that is subjected to an absolute ban. Heller Bruin, end of story, that's all you need. Justice Thomas in his Friedman dissent from cert said, when you have an arm that's owned by millions of Americans, that's all that's needed for that arm to be protected by the Second Amendment. And that's the law now in Bruin. And I thought, well, that's the law. What are they going to say? Well, they didn't say anything other than that. And so we are right back where we thought we would be at this time. The law is before the court. The court will evaluate it. I think that we have done everything we can to make the facts in the law clear to the judge, and I think we should prevail.
And they tried to claim that somehow that these are not common use for self-defense.
That's right.
Which was a real twisting of the words, right?
So I mentioned the Freeman statement that Justice Thomas said. He said, there are millions of ARs out there. That's all that's necessary. He didn't say, we need an empirical study about how many of those have been actually used in a self-defense situation. And only then can we evaluate whether they're appropriate for self-defense and make the decision. No, that's not what he said. The mere fact that there are millions out there. Heller. The fact that they're chosen by the overwhelming majority of Americans who own these handguns, the mere fact that they're chosen, not that they're used in a particular way, is sufficient. Well, the state's saying, well, no, you've got to do some sort of study on how often they are actually used, which has never been the law.
When you have a magazine, which they call large capacity, we call them standard capacity magazines in a firearm, you don't actually have to discharge the firearm for self-defense.
That's right.
Just the fact that you possess it in any manner, in your car, on your person, in your home, anywhere, should be prima facie evidence that you believe in self-defense, you believe in sporting purposes, you could believe in any number of legal activities with that firearm, and therefore that's how it's used. Well, of course, they were trying to argue, show us all these examples. Remember, the burden of proof is on them.
That's right.
In this case. They've got to prove this. We brought the case, but they have to prove that it fits within the text and history of the Second Amendment, and we know that doesn't.
Yeah, that's the beauty of these cases post-Bruin. Back in the pre-Bruin days, under the intermediate scrutiny era, there was always arguments about whether it's a good idea to limit these. And you know what? We always lost those arguments because all the circuit courts said, well, under intermediate scrutiny, state wins. That's basically that was the rule. And Justice Thomas said, no, you've been doing it wrong. All these are abrogated. That means those courts are rendered irrelevant, useless, no longer precedent on these points. And he said, if it's demonstrated that it's a bearable arm, that's all you need to do. And these are bearable arms. And then it's up to the state. The law is presumptively unconstitutional. If you're trying to hold a bearable arm, the state can try to rebut that presumption of unconstitutionality by saying, well, no, it's also it's consistent with our history and tradition. But if they can't, the state loses, and unconstitutionality is not rebutted.
And I think the shocking thing to these people is, remember that Hawaii enacted this, quotes, assault pistol, short ARs, way back in the 90s, I think. Right. And they enacted this law, but today the prevalence of AR-15s is at least 10-fold, maybe 30-fold of what it was back in those days. And then you also add in the concept that in the last 5 years, the pistol brace AR, which is essentially AR-15 pistol is also prevalent. It's the widest selling firearm and AR-15 model. And that all fits within their statute. So there's no question about how common it is. Across America, it is ludicrously common.
Tens of millions.
And I would say if it weren't for this being an island where it's difficult to get them here, it would be everywhere in this state, even if they were illegal.
Right.
Citizens would have them here, but because this is way out in the middle of the Pacific, it's easier for them to restrict it.
So a lot of things have changed since they passed this law in the early 90s. For one thing, Heller wasn't until 2008, where for the first time the Supreme Court held that the Second Amendment definitely protects an individual right. And then McDonald didn't come along in 2010, where the Second Amendment is applicable to the states. And then the circuit courts screwed it up for an entire decade with this intermittent scrutiny nonsense. And so it wasn't until less than a year ago where Bruen cleared the air and made it possible to challenge the Hawaii law.
Here's a weird part about all this. We filed this lawsuit like many of our other federal lawsuits on assault weapons ban, magazine bans, and it really stirred the pot. In fact, the U.S. Senator from Hawaii, Hirono, was in the Judiciary Committee in D.C. complaining about this particular lawsuit, said this could derail all of Biden's gun control agenda. We're like, hey, that's a great idea.
Our cases are having repercussions even if we don't know. We know that in the committee hearings on one state's assault weapons ban, they basically said, we're spending a lot of money defending these and it doesn't look good for us. And so they basically gave up.
Yeah, they gave up in New Mexico. Looks like they might be giving up in Colorado. The fight's really happening. So if you haven't signed the petition and supported these lawsuits, we need your help. We're out here. This is the easier part of the duty, being here in Hawaii, but we're all across the country fighting these lawsuits, including Massachusetts, Connecticut, 2 in Illinois, those in Colorado, and we're looking for others. So make sure you're a part of what we do.